Welcome back to the deep dive. I want to start today with a visual. Imagine for a second that you are trying to build a house. You've got the contractor's piles of bricks, the mortar, and you have this blueprint of what it's supposed to look like. But while you are physically laying the bricks for the living room, the people already camping out in the half-built kitchen are, well, they're screaming at each other about who actually owns the blueprint.
That is a chaotic image, and honestly, it sounds incredibly stressful.
It is stressful, but it's also a remarkably accurate metaphor for the situation we are looking at today. We are talking about Somalia, and usually when you hear about Somalia in the news, the conversation just drifts immediately into politics. Who's shaking hands with whom, who is upset, the security situation, it's all very in the moment.
Right. It's the daily churn. It's the headlines, not the story.
Exactly. But today, we're doing something different. We're ignoring the politics entirely. We're looking at the rules of the game. Specifically, we're unpacking a dense and I think fascinating legal interpretation of the 2012 Provisional Constitution of Somalia.
And this is such a crucial distinction to make right at the top. Politics is the noise. The Constitution is the signal. To help us tune into that signal, we are doing a deep dive into a legal opinion by Abdullah Mohoddin Hassan, also known as Abdullah Yabro.
Okay, and before we get into the heavy legal lifting, and trust me, we are going to get into the weeds, give us the profile on him, because his background actually frames how we should read this, doesn't it?
It really does. Hassan isn't just a lawyer. He's a master of law, a Somali legal scholar specializing in public international law, sovereignty, and recognition. But here is the specific nugget that makes his work so relevant for us. His research focuses on the structural inequalities that affect weak states.
Weak states. That's a term of art in political science, right? Sounds a bit harsh, but it has a specific meaning.
It does. It refers to states where the institutions, courts, police, bureaucracy, tax collection, they might be fragile on the ground. They might not have a presence in every village. Hassan explores this fascinating paradox, how a state can be institutionally fragile in reality, but still possess robust, unbreakable legal protections on paper.
So that's the tension. His argument is that even if the government building hasn't been painted yet, or even if the roof is leaking, the law that defines the building is still solid.
Exactly. His core premise in this paper is that despite all the political noise and the fragility of the state, the legal text, the Constitution, is actually quite clear. The confusion isn't coming from the text itself. It's coming from how political actors are choosing to read or misread it.
Okay, so our mission today is to cut through that intentional confusion. We're going to unpack 4 specific articles, 53, 54, 138, and 142. Now, I know listing numbers sound dry, but based on my reading of this, these 4 articles are basically the load-bearing pillars of the entire country.
They are. If you remove one, the roof caves in. These articles determine how the nation holds itself together legally while the institutions are still being built. They answer the fundamental question, is this one country, or is it like 5 small countries wearing a trench coat?
That is the question. So let's start with the biggest aspect of that, the power dynamics. Who gets to do what?
This brings us squarely to Article 54. In the world of constitutional law, this is what we'd call the structural clause. It's the divider. It explicitly divides power between the federal government, the FGS, and the federal member states, the FMS.
And usually in federal systems, this is where things get messy. You have states' rights versus federal power. We see this everywhere. But from what I gathered, Hassan argues this isn't actually a gray area in the Somali text. There are things that are strictly hands-off for the member states, right?
Correct. And this is vital for you to grasp. Hassan identifies 4 specific areas that are exclusively federal. These are the non-negotiables. If the federal government doesn't control these, you just don't have a country.
Okay, hit us with the list. What are the big 4?
Number 1 is foreign affairs. Number 2, national defense. Number 3, citizenship and immigration. And number 4 is monetary policy.
I want to pause on these because they seem obvious, but maybe they aren't. Foreign affairs and defense. Okay, that makes sense. You can't have 5 different armies.
Right.
Citizenship, you need 1 passport. You can't have a California passport and a New York passport.
Right. Those are the standard attributes of sovereignty.
But monetary policy, why is that on the exclusive list? Why is that as important as the army?
Well, think about the alternative. Imagine if you drove from one state to another within the same country and suddenly your money was worthless. Or imagine if one state decided to print $1 trillion of its own currency to pay off debts, causing hyperinflation that just ruins the economy of the state next door.
It would be economic anarchy. You couldn't do business.
Precisely. You cannot have 5 different currencies or 5 different central banks in one sovereign nation. That leads to immediate economic fragmentation. Hassan notes that this allocation reflects classical federal theory. If you look at established federations, the US, Canada, Australia, the central government must hold these 4 powers. If it doesn't, it effectively ceases to be a unified state legally and politically.
It becomes just a loose alliance of little countries,
Yeah,
like a club rather than a nation.
exactly. And that is what Article 54 prevents. It locks those 4 powers in a vault and gives the key to the federal government.
But here's where it gets really interesting to me. The source mentions that everything else, anything not in that big four, is up for negotiation.
Yes. And that is a massive distinction. The Constitution is rigid on the existence of the state, survival stuff, but it's flexible on the management of the state.
So things like natural resources, oil, minerals, fisheries, those aren't on the exclusive list.
No, they aren't, and that surprises a lot of people. Article 54 implies that resource allocation and other domestic matters are subject to negotiation between the FGS and the FMS.
That feels like a very specific design choice. It's almost saying, we need to agree on being a country, but we can argue about who gets the oil money.
It reflects a dual commitment. You need national unity for the big stuff, survival, identity, money, but you also want subnational autonomy for the local economy. It lets the states feel like they have a stake.
So, to clarify for the listener, the big statehood stuff is federal, but the internal economy is a conversation.
Exactly. For instance, if there is oil in a specific member state, that state and the federal government have to sit down and figure out a resource sharing agreement. However, and this connects back to the exclusive powers, if selling that oil requires an international contract.
Then the feds have to step in.
Correct, because that falls under foreign affairs. The federal government is the only entity recognized under international law. A member state can't just sign a treaty with a foreign oil company on its own behalf.
Because that would violate the foreign affairs exclusivity.
Bingo. You can't have it both ways.
That is a perfect segue, actually. Because if foreign affairs is exclusively federal under Article 54, why is there so much arguing about states talking to other countries? I feel like I see headlines about this all the time. Regional leaders meeting with foreign diplomats, making deals, bypassing the capital.
This is where we have to look at Article 53. And this is where the interpretation of words becomes incredibly important. We are getting into the weeds of legal language now, but it's where the battle is being fought.
We love the weeds. Words matter. What does the text say?
Article 53 says the federal government must consult the federal member states in the formulation of foreign policy on issues affecting their interests.
Consult. That sounds friendly. It sounds democratic. Hey, what do you think about this?
It is friendly. It's designed to be inclusive, but the conflict arises because some political actors interpret consult to mean we need to agree or we share this power. They see it as a requirement for consensus.
Ah, I see. They think consultation means veto power. Like, you can't do this unless I say yes.
Exactly. But Hassan's legal analysis is very firm on this. Consultation is procedural, not a transfer of sovereignty. It's a box you have to check, not a barrier you have to cross. He sets a really interesting case from Canada to prove this. Point Canada v. Mikisew Cree First Nation from 2018.
I love when we bring in international examples because it shows this isn't just a Somali problem, it's a universal legal question. What happened in the Canadian case?
Well, the Supreme Court of Canada had to define what consultation actually means in a legal context regarding Indigenous rights and legislation. The First Nation argued that because they had a right to be consulted, they effectively had a right to shape the final law.
And what did the court say?
They clarified that you have a right to be heard, you have a right to participate in the decision-making process, but that does not grant you a veto. The duty to consult is about respect and information gathering, not about co-governance.
So let's try an analogy. It's like, if I'm cooking dinner for a group of us,
Okay, I'm listening.
I have to ask you if you have any allergies. I should probably ask if you hate mushrooms. That's consultation.
Right. You are gathering the necessary data to make a good decision.
But if you say, I want pizza, and I decide to make tacos, I haven't broken the law. I consulted you, I heard you, but I made the executive decision because I'm the chef.
That is a fair way to put it. You can't demand to take over the kitchen just because I asked what you wanted. And this matters for Somalia because external sovereignty demands what lawyers call a single international personality.
A single international personality. That sounds like a therapy term, but break it down legally.
It's crucial. Think about it from the perspective of other countries. If every member state could negotiate its own treaties or block foreign policy, other countries wouldn't know who they were dealing with.
It would be confusing.
It would be legally dangerous. You get legal fragmentation. If France signs a deal with Somalia, they need to know it applies to the whole country. They can't have a regional governor popping up 2 weeks later saying, actually, that doesn't apply